Okay, there we go. Thank you. I'm Jeff Kleinman for Valley Neighbors for Environmental Quality and Safety. Um, at the outset, let me tell you who is ceding time so you can check it off. In addition to Ms. Abels, we have Kent Fields, James Rodell. Kent Fields, I'm not sure I have. Kent Fields, I believe, is in position 21. And then James Rodell in position 23, Josh Dotson in position 24, Andrew Ould, O-U-L-D, in position 32, and Jennifer Johnson, I'm not sure what position she is in, but that would be a total of 21 minutes, including my own time.
And Ms. Boulder, have you adjusted the clock appropriately?
I am about to.
And if you could display it, I would really appreciate it. It was displayed for one witness, but not for another.
Is it not showing on the phone?
It doesn't show until
Oh,
it will display as soon as we start the timer.
All right.
The timer will display as soon as it starts, so please proceed.
Jennifer Johnson.
I have Jennifer Johnson.
Okay.
She's on the new list.
Great.
Okay, I don't see the clock.
Are we okay to start?
Yes.
Okay.
I'm told once it starts.
Here we go. Jeff Kleinman, 1207 Southwest 6th Avenue, Portland, 97204. I guess for the lawyers for the parties in this case, you're getting a couple of old Jeffs. What can I tell you? As a couple of preliminary matters, it's my understanding that staff might be unwilling to distribute written testimony that you're handed tonight to the members, which is going to be essential to follow along, not necessarily on mine, which has also been electronically filed, but some folks have numbers they want to review with you. So I hope that staff will, in fact, distribute the hard copies tonight in front of you. Also, joining Mr. Condit's request that the record be held open for 14 days for additional written submittals. So please bear in mind, as always, that the burden of proof is on the applicant in this case. Just some history here. There has been a commitment to fully and permanently cap and close the landfill and restore the site to its original condition, reflecting the pastoral character of the area, ever since the county's adoption of its only duly adopted solid waste management plan, the 1977 plan, a copy of which we attached to our memo as Exhibit A. This commitment has been made repeatedly and has repeatedly not been fulfilled. It was contained in the 1983 adoption of the zone. It was revalidated in every land use decision affecting this dump in 1994, 2001, 2003, and most recently in the 2021 application, which was denied. As Mr. Penning said tonight in his testimony, very little lasts forever, but it appears that this fill is really going for it. And I'll point out too that since the mid-1990s, none of the cells anywhere on the landfill site have been sealed or replanted. So everything, whatever the applicant says about the quality of how they manage things, everything is covered with a bunch of mismatched, ugly tarps. There's been no capping, no sealing, no landscaping. And what they have is instead a bad neighbor policy writ large. And it's a bad neighbor policy which continues to receive Benton County's seal of approval. One question here, what is the darn rush with going forward with this application? They have wrapped up operations on the 59-acre parcel adjoining Highway 99 north of Coffin Butte Road. They have begun operation in the Knife River Quarry site that Republic owns directly to the west, also north of Coffin Butte Road. And that site has 12 to 14 years of capacity. So why not do that and leave the folks to the south alone for now? I would also point out to you that with the closure of the 59 acres and the opening of Knife River, the capacity limits that were formerly established are gone pursuant to the franchise agreement between Republic and the county. So it's Katie bar the door on the amount of trash coming in. All right, then on the subject of the staff report, I think staff made a diligent effort with excellent graphics and all in spite of Petra's terrible cold, and seemed to clearly understand the issues that face the county here. We agree with the determination that the application must be denied, that the applicant's not met its burden, but there are other reasons for that beyond the couple that staff found, and folks are going to address that tonight. Bear in mind, again, the applicant has the burden of proof. I'm not a fact witness, but the fact witnesses are here. They're well organized. They understand what's relevant and what's not, and they will present it to you in an organized manner with relevant material. And along with that, I'll point out that staff didn't have the benefit of the written and oral materials that the opponents are submitting. So to the extent that staff did not cover everything, that makes perfect sense. This is the time for the other evidence to come in. And it's not just the movement, the proposed movement of Republic's operation toward the south now, toward previously unaffected or less affected properties that will cause the increased impacts in question here. The movement to the south will serve to sustain a dump that would otherwise close at a certain period of time, within a certain period of time, for 6 more years, a minimum of 6 more years, assuming they confine themselves to the limited height they're proposing for this area to the south, the site that's before you. And this addresses the character of the area, which I'll talk with a bit more, but there has been an emphasis on the part of the applicant, perhaps accepted by staff, that the character of the area is an existing dump. So that does not define the character of the area. Aside from all the surrounding uses, including farm uses that will be discussed with you, what we now have is a dump that would close 6 years earlier without the approval of this. And that's part of the character of the area. We also have the movement and the effect on additional previously less affected or unaffected properties. So to the extent, and also part of the character of the area is the expansion of the Adair Village UGB. That is an existing part of the character of the area. So to say that an existing dump is part of the character of the area does not really define the necessary elements of the character of the area. Staff did not get to conditions of approval because they're recommending denial. But I will say that Benton County can impose as many conditions as it can dream up if this application is approved. Unfortunately, the applicant's existing operation has a solid track record of non-compliance with conditions, and the county has a solid track record of failing to enforce conditions. There's a question to a prior witness about what's your proof, and that will be introduced into the record by fact witnesses. who know what those violations are. Also got a couple of initial comments concerning the work product of the Benton County Talks Trash Task Force, which for the most part consisted of citizens working hard on long-term garbage-related issues. First of all, most of those folks worked really hard and were really diligent in trying to address those issues, but two things need to be made clear. First, the task force report to the Board of Commissioners was accepted by the board, but not deemed received. I'm sorry, and was deemed received, but it was not formally adopted as county policy. If it had been, we would have appealed it to LUBA. So it is not binding upon you, and you will determine the meaning of the code in this case. Second, a completely different kettle of fish was the legal subcommittee of Benton County Talks Trash, which proposed certain interpretations of character of the area, serious impacts, and that sort of thing. That task force included 4 attorneys, 2 of which work for Republic, and one of which is your county counsel, who has been a good friend of the landfill. Hate to say that, but he has been an advocate. And then there was a 4th attorney who would have been neutral. So to the extent legal considerations or suggestions came out of that task force, kindly disregard them. If you're inclined to be persuaded that approval of this application would not result in serious interference under your conditional use criteria, please picture yourselves as homeowners or farmers at or near the expansion site. We can pretty much guarantee that you would find that the proposed operation seriously interferes with your use and enjoyment of your property, as well as with the character of the area. Under no circumstances would you move to or wish to live anywhere near the site, even with the low prices that will result on property sales in that area. You'll have testimony that the prospect of an expansion causes potential buyers to back out of home and farm purchases. Being unable to sell your property is certainly serious interference. If the interference and the impacts were unserious, as Republic suggests, why did Republic need to haul in so many consultants to persuade you otherwise? And why have so many people signed up to testify in opposition? This applicant has a track record, and it's a stinky one, and a loud one. In the time I've got remaining, I'm going to talk a bit about your conditional use approval standards. First, under 53.215, the general conditional use approval standards. First, the proposed use does not seriously interfere, that's the applicant's burden proving, with uses on adjacent property, which has been broadly defined in the staff report, with the character of the area, and with the purpose of the zone. In terms of the character of the area, we would posit to you that that the scope of the area is not necessarily a rectangle, but is an area defined under the law, under land use law, as the area within which people are able to demonstrate impacts. So please pay attention, as you will, to the testimony you receive, because some of that will go beyond the defined area that's noted in the staff report. Okay, so when you have an opportunity to get into my memorandum, we discuss the conditional use criteria in some detail. First, what is the meaning of seriously interfere under the code? And we propose a definition there that goes through the steps using Webster's Third International Dictionary, which is the source that's used by LUBA and by the Oregon Appellate Courts. And the definition we suggest is as follows. Seriously means to a serious extent. Serious means significant or likely to have influence or effect, deserving to be considered, not of little size or importance. So to the extent that the legal task force on BCTT suggested something more narrow than that, we disagree, and you'll have my proposed definition and interpretation to look at. It would be a disservice to both the surrounding community and to the development code itself to artificially constrain the effect of this approval standard. So then you reach interference with uses on adjacent property. There's been a mapping, as I indicated, it, I think it's at page 20 of the staff report, that shows those, and those include some farms that will be subject to impacts on farm practices, which falls under another provision of the code that's discussed in our memorandum. I think any affected properties should be deemed adjacent as well, to the extent that the evidence supports that. The most intrusive and disruptive impacts generally within the adjacent area for non-farmers and farmers alike are noise and odor impacts and wind-blown garbage from the operating landfill. With respect to noise, you've heard that, first of all, DEQ's regulations are outdated. Second, DEQ no longer enforces to the extent it ever did. Some question as to whether DEQ enforces much of anything ever, but that's an editorial comment. And therefore, the noise impacts that have to be considered, and the code does not confine itself to DEQ standards anyway. So it's the noise effects on the adjacent and surrounding areas with respect to which you will receive testimony. Staff recommended denial based on noise impacts. We agree, but aside from the fact that noise regulations are unenforceable, I will mention that one of the particular supposed mitigations proposed by the applicant is that at least their own equipment will have so-called proximity beepers that don't operate all the time, only when their radar detects something behind them. Those beepers are much louder. They're like alarm clocks. So they have their own dramatic effects. And only Republic's own equipment, not all the customers coming in from various companies and individuals, will have proximity beepers. So that's a minimal, if any, mitigation. I would also suggest to you that the science of acoustics does not lend itself to straight line calculations of noise effects, depending upon atmospheric conditions, wind conditions, respective elevation. So the area that will be affected by noise will be quite broad and not confined. The other impact that staff recommended denial based on is odors, and you'll have plenty of testimony about odor impacts. And these impacts affect not only residential uses and people's ability to enjoy the outdoors on their own property, but also there's testimony, written or oral, that farmers are affected because the people they bring in to work, the farm crews, don't want to be there. It's a function of both noise and odor. They don't, given a choice, they don't want to work on a site that stinks and has those incredibly annoying noises. So it's harder to attract labor, and that affects the ability of the farm to operate. Then we have the consideration of visual impacts also count. And when the mountain of trash arises to the south, that's a new visual impact on the people to the south, including one household that's directly adjacent. And they will provide at least written testimony as to that. As to interference with the character of the area, I've already talked about the baseline character of the area being erroneous, as previously described to you by the applicant and staff. There's a lot more to take into account in terms of the character of the area. And you also need to take into account the use and enjoyment, hopefully, by members of the public generally, of the E.E. Wilson Wildlife Area to the east, and the use and enjoyment of the trail, which also adjoins on another side of the site. So by definition, moving the fill operation south of Coffin Butte Road will seriously interfere with the character of the area to the south, as well as to the east and west. All of this will come to you in the form of first-person testimony as to the evidence. Starting at page 13 of my memorandum, we discuss the findings and actually quote verbatim from the Planning Commission's findings in denying the 2021 application, to the extent that those are directly relevant to this application, and only to that extent we've set them out here. In terms of the forever nature of the applicant's operation, in a footnote on page, I believe it's 13 of our memo, we note how if there's a fill operation on both sides of Coffin Butte Road, which would now occur if this is approved, it would be very easy for the county to revisit the closing of Coffin Butte Road, as the applicant wishes, by vacating it when there are favorable landowners on both sides, and the county can go through a simplification and the applicant doesn't have to apply for it. There would be a very limited process for that. So then they could dump over Coffin Butte Road and seal it up. I am going to stop there because I've got 4 seconds left, and I'd be happy to answer any questions.
Thank you for your information. I have not had a chance to review your memorandum yet, so my question may be answered in there, but you made a reference that land use law defines what a character of an area is. Can you provide what that land use law is? Or
yeah, this was discussed in the first LUBA decision in Stop the Dump Coalition versus Yamhill County, which I don't have a site handy for, but can provide during the open record period. And in terms of the significant impacts test there, the applicant tried to arbitrarily define the area that should be considered for those impacts. And Luba said that you actually have to look at what the evidence is, and to the extent necessary, then broaden the area. So that's it.
Yeah.
Mr. Kleinman, you made 2 comments in your testimony that I'd like, if you have some further clarification. You referred to the Benton County Talks Trash Work Group report that was accepted and deemed received by the Board of Commissioners here at Benton County, but not formally adopted. I'm missing the nuance of significance there. You've stated it, so is there more context to that?
Yes, thank you. The report was handed into the county and handed to the Board of Commissioners, and they said, we accept it. That was the resolution. So basically, thank you for your work, and here it is. if it had been formally adopted, that would mean that the recommendations, the findings, the interpretations contained in that report, including the legal aspects, would have been formally adopted as policies of the county, regardless of what the code provides. And that is not their effect because the report was only accepted and not adopted as the policy of the county or the Board of County Commissioners.
Thank
So
you. And then,
the interpretations aren't binding.
thank you. I'm sorry.
Yeah.
Have you, okay. My second question is just a brief one. You were talking about definitions. You referred to a LUBA reference, a dictionary, if you will, legal dictionary, and you also referred to a second one, and I just didn't get enough notes, but you did refer to
Yeah.
both resources.
Yes, it's set out in our memorandum at some length. And what I said was that the definitions of certain terms that are relevant here, in particular, serious or seriously interfere, can be interpreted through Webster's Third International Dictionary. I believe it's the third edition, is what's formally recognized by LUBA and by the appellate courts for providing the meaning of ordinary terms that are not legal terms. And that's what these are. So you go to the dictionary, and that's the dictionary they use. So we walk through that in the memorandum.
Thank you.
Thank you, Mr. Kleinman, and I think I heard you indicate that you would be asking for a 14-day period. I've made note of that, and of course, those procedural motions will be considered.